All right, so now we're going to have a benefits update with David Mahoney and Mark Gajowski.
Good, we're hot. All right, so this afternoon's presentation, as I jokingly said, David and myself are going to do the best we can to educate you on some really, really esoteric and deep topics. Right, David? He's familiarizing himself with the content material now, so this should be very, very enlightening. I myself have had at least 6.5, 7 seconds to look at the slides, so this should be really insightful for us all. Kidding aside, we're going to talk today specifically about employee benefits as it relates to you as maybe plan sponsors or specific language fiduciaries, as well as when I pass it off to David here momentarily, talking very specifically about employee benefits law and things you need to be mindful and aware of. Specific to my presentation today, ERISA plans, or the Employee Retirement Income Securities Act, for those of you who are so interested in answering the Jeopardy question right, inevitably, which will come up, and the burdens imposed upon plan fiduciaries. This is something it's hot. It's a hot topic right now. It's in the news. So if you ever want to know what a fiduciary is, I'm going to try to do my best to educate you on that today. So specifically and why it should matter. If any of you are employers or touch plan assets. So let's talk about a plan. What is a plan and what denotes a fiduciary? Just by random show of hands, who is or works for an organization that's got a 401k or 403b plan? All right, so better than 3/4 of the room. So that concept would mean that most of those plans, if not all of those plans, where your employer has money in that they've segregated from your paycheck or that they're making contributions on your behalf, those plans fall under ERISA. The benefit to us as employees is that ERISA is meant to protect us, that employer doesn't commingle our funds with theirs, that they don't misappropriate our funds, that they do the right things for us. And there is a very broad swath, if you will, of who's caught by fiduciary. Up until very recently, how recent, June 9th, in fact, the government mandated that fiduciary status takes on a much more inherently deep and material benefit for us as employees and for us as plan sponsors. And plan sponsors are those people who sponsor a plan. So if you're in a capacity where you are the executive director, co-executive director, you're the person who's remitting the funds as a payroll person at the non-for-profit, you're all considered fiduciaries. Sorry, got to be the one that breaks the news to you, but you are now caught up in that category of being a fiduciary. And the reason for that probably is because the government wants to make sure that employees are held to the highest degree or the highest accountability standard. We'll go through a couple of slides where it talks specifically about the language of that law. But generally speaking, to kind of get to the slides here, ERISA covered plans include such things as any retirement or welfare plans. So let's say that you have several hundred employees in your organization, you file a 5,500 filing for your group medical insurance plan. That also falls under ERISA topics. Rules also apply to any specific items. So again, 401ks, 403bs, whether or not the money has material matched to it or not. So if there's deferral money that's being remitted, those things are all covered topics. The most important thing is the definition of a key player. So again, we talked about plan sponsor. The government is notorious for trying to make language really complicated, probably so they can catch you. In which case, folks like myself, David, and Ken wouldn't have jobs if we weren't able to help out in some material way with breaking down these things. So anytime you see plan sponsor, think employer. Feel free to write it out on your slides. They're your slides to bring home. Named fiduciary is someone who's got their name listed somewhere in the document. You sign for it or your name is somewhere in there. That's what's called a named fiduciary. Why don't they just say anyone whose name is in the documents anywhere by name? That would be really just too specific and probably too simple. A trustee is someone who's responsible for the money. Typically, that always includes the employer. Even if you've outsourced that to some other organization, you, by nature of being an employer, fall into that category. And of course, the plan administrator, and that is also a very broad topic. So that is the financial advisor, the broker, the custodian, the record keeper, anyone who's touched the assets, and of course, anyone who's directly materially affiliated with the employer. And really why you should care on this is because as a fiduciary, you're A, held to a really high accountability standard, and two, you're personally, financially responsible for any and all oopses that were made, whether or not you believe them or not. Now, my colleague Dave, over a very nice lunch we had the other day, it was a nice lunch, right? Very nice lunch, high end. Thank you, by the way, Ken, for picking that lunch up for us. It was very nice of you. Over a very high-end lunch, we discussed something which I thought was a very good thing, so I'll share it with you. David, as an attorney, said that ignorance is not a legally defensible position. And I always thought that was one That's a good one. That's like you write down, like, I'm going to drop this the next time in an elevator and someone asks you what you do. So ignorance of the law is not a legally defensible position. So now that the government's out there, they're advertising this stuff, people are trying to make you scared or aware of what a fiduciary is and why it matters. That's that key word in that standard is you're personally financially responsible for any and all rules that fall under you as a fiduciary. June 9th, this law came into effect. There's a interim runout period between June 9th. This law essentially goes into effect January 1st of 2018, of which, and after which that point, everybody that falls into these categories is held accountable in that way. So exactly what does that mean and why does it matter? We talked about kind of who's covered in this specifically, but the actual acts. So one is by name. Again, they try to make this more complicated than it needs to be. Exclusive loyalty. So your actions as a fiduciary. So again, the fiduciary roughly covers anyone and anyone who could potentially touch the assets, advise on the assets, or otherwise is named in a plan document anywhere. You must act for the exclusive benefit of the people in that plan. Seems pretty obvious. And we all know that, of course, every employer does this just by sheer nature, that you're always absolutely 100% accountable to everything that you do. Well, technically, up until this law was into effect, that was not entirely true at all. That was the assumption. The reality, however, was something completely different. So you could have had your brother-in-law, cousin, good friend of yours from college, just the person you knew from around the block, advising you on your plan or being involved in a plan or helping you pick funds for that plan or advising in that plan in some manner or method. And you just assume that they were doing the right thing and that was good enough. The reality is today, now with this law is in effect, that is not good enough. They're holding you to an accountability standard. You have to prove that the things you're doing in these plans are in fact right, that they are true, that you tied these things out, that you did some measure of research to make sure that these plans are correct. Again, exclusive benefit of making sure that these things are right. The other thing which I will note, which is kind of the last sentence in here, is paying reasonable expenses. I love it when, and no disrespect to my colleague Dave, because attorneys, they get paid good wages to come up with this stuff. Reasonable is a pretty vague word, right? If we were on that and we're on the webinar, we can go air quotes. Reasonable is like one of those, reasonable. Well, what's reasonable? Well, let's say if I lived on the North Shore of Long Island, reasonable to get your kitchen done is probably not what's reasonable to get it done if you lived in the middle of the country somewhere. So reasonable is relative, right? So anytime you see reasonable, you can cross that out and write relative. So it's got to be accounted for. Let's say that you have an advisor in your plan and this person comes in and they sit with each one of your participants and then maybe they're all over it and they're doing a really great job and they're there all the time and you really believe that they've done everything right and they give you all this great documentation and they show you relative fees of your plan, your size, your industry, geographically local to where you are, and you can document all those things. I would say that, if you want to maybe overpay them, if that's in case if that is in fact the case, then by all means, that's fine. You have a basis to compare that to. Reasonable, right? So just because someone is charging you a fee or maybe a slightly higher fee or slightly lower fee doesn't mean you're getting more or less. So again, attorneys, again, as an example, high-end accountants such as Ken, other professional advisors who charge fees for service does not make them more or less efficient or more or less ethical than anyone who charges less. And sometimes we use this in an example. Ivana, my colleague in the back, who you turn around and wave, she and I did a presentation about a couple of weeks back and we talked about fees relative to investments. And everybody's always concerned about getting the absolute lowest cost for something. The reality is we never shop with lowest cost in mind. Because the reality is that the basis point differences, the small amounts of money that differ from one retirement plan to another are so insignificant when you put it into a reality. That's like the difference of paying $500,000 for a home or paying $499,000, $800. When you get to a larger dollar amount is a significantly smaller amount. Companies like Vanguard and Schwab and others would lead you to believe that, of course, the lowest cost is absolutely the best. The reality is most of us never shop by cost first. We shop based on what? Price to value. Price is always the issuance of value. Unless there is no value to be had, then of course price becomes a fair runner-up for second. So again, exclusive loyalty, make sure you're benefiting your plan participants. You also must act in or as a prudent person. So, and I'm not going to reread this, but duty, skill, care, someone that is accounted to for that title. How are we doing on time, Ken? Good? Good? So again, you have to make sure that you're selecting other fiduciaries. If you're outsourcing things, you have to prove that you're tracking these other people who are responsible for it, that money is being remitted timely, that those fees are in fact, at least comparative or relative for the value that you're getting. And you have to document this. Again, the court God forbid you ever got called into something from the IRS, Department of Labor, or even got into a court situation. And every big company that's out there, including the biggest of the big, which is like Fidelity was even sued by their own employees for not using the lowest cost share class in their own 401k plan. That was honestly just like it was like tongue in cheek, like really the biggest 401k plan out there was sued by their own employees. The only way you can sue your own employer, by the way, is through something like this, for not using the absolute lowest cost available shares at Fidelity. So be mindful that it's out there. It creates litigation. It creates an accountability that you didn't otherwise have before. Fiduciary duties. You have to make sure that you're diversifying the plan investments. Back in 1974, when ERISA was created, one would think that there was actually less funds available. The reality is the average number of funds that were offered in a 401k or 403b plan back in the 70s and early 80s the average was 54 investment options. That's what you had to choose from, not choose from, to narrow down the list of what your employees actually picked. That was the total number of options you had in your plan. Very confusing. Nobody was sitting there and with you making sure that you picked the right funds. You had to pick whatever you picked. The move has gone substantially in the other direction, which is now there's less options. Those options are more diversified, on average lower fees because of competition. And because of this new accountability standard, everybody's very mindful that if they say the funds are going to do certain things, they're actually doing them. We'll remember the late 90s and early 2000s when Janus as one, see, I'm equal, I talk about every other company. When Janus had their ship going from the bottom of your screen to the top, and it said something like the ship was coming up and the words were going down. And it said like, Janus did the research on this cruise line company, and we found that they were going to do whatever amazing thing they did before they did it. And that's why our mutual fund is up 100% this year. Didn't make those numbers up. You guys remember how that tech bubble burst in late 90s and 2000s. So, and all the fund companies were doing the same thing. They weren't disclosing the investments they had. A lot of that stuff, thankfully, has been cleaned up since. Fiduciary was one of those big parts to this. A couple of last slides here as we're kind of ripping through this. You have to make sure that you're avoiding prohibited transactions. So I run a third-party administration company out in Hauppauge. So that's why we work together with Ken and David and others. And we work with a lot of 401k, 403b plans to do the administrative side of the plan, the kind of less glamorous stuff, right? It's the tax returns of the retirement plan. You have to file these returns every year. So we get pulled to task oftentimes by small employers, which is most of our client base, coming to us and saying, Mark, we've got to put away a big contribution. We had a really banner year. We want to put away a $2 million contribution. Here's our census, here's our staff, and OPS. I want to invest all this money in this building that I'm going to buy, but I'm going to put it in a separate LLC, and I'm going to own it, and I'm going to pay myself rent, and I'm going to do this like really complicated investment, and is that cool? Love it when they put it to you like that, right? And of course, it always comes in an email because they're expecting like you're going to email them back. So inevitably, my staff knows enough. We get on the phone. Hey, Bob, what's really the story here? What are we trying to get to? Are we trying to get the tax break and the deduction, which your broker and your accountants had brought us to, which we created this really great plan for you? Well, yeah, of course, I want that, right? All right, but now you're trying to go in and kind of commingle those investments that are really not for your personal benefit, but for the benefit of all your staff into some real estate that you personally own, right? Well, again, I'm going to personally own it, Mark, but I'm going to own it in another company. All right, well, does it look like a duck? Does it talk like a duck? Does it walk like a duck? It's probably a duck, pal. So P.S., it's a prohibited transaction. You can't do that. That's a no-no, right? You're now not in the gray area. You're way out. So inevitably that comes up, and I use that as an example because it happened just a couple of weeks ago. But again, you got to be careful that you're using the plan for the benefit of your employees, not for yourself. That's why plans and firms like us exist. So now that we know who a fiduciary is, why it matters, that there's some teeth in these things, how do you limit your liability? Well, clearly you want to make sure that you at least go back if you're affiliated in a plan, that you're looking at all these necessary roles and responsibilities and making sure everybody's doing the things that they are doing. So if you have not heard from your record keeper who holds the money, your broker advisor who's supposedly advising on them, and no one's talking about this, and P.S., I know for a fact a lot of these companies are not talking about it, even though it is now the law of the land. There's a reason for this. The reason is most of the big law firms who advise in this area specific to fiduciary standard and fiduciary law are telling them, hey, listen, because it's an interim law, anything could happen. Maybe it doesn't get to January. Maybe they change it. So since it's still in this wishy-washy period, just be mindful that you can't say anything formal. But they can legally and absolutely should be coming to you and saying, hey, listen, there is something out there called fiduciary. Here's that potentially could affect you. Here's the potential exposures of your plan. And here's what we may or may not need to do when and if this comes into effect. That's just good advice, right? You would want that. You want someone to call you on it. You don't want to find out after the fact that some random person who doesn't know your plan from anyone looks you up online. P.S. Unlike tax returns, your 5500 filing, which proves that you have a retirement plan and how much money is in it, these are public record documents. They're open, so I can download them just like I can any of your 990s for non-for-profits. They're out there. People call and have been calling off these things for a while saying, hey, listen, I noticed you've got some money that's been going in late. You've been filing late. You haven't shopped your plan in a long time. You're paying excess fees or relatively excess fees. Again, they don't know. They'll say anything they want just to get the foot in the door. So be mindful of that. You can also outsource your fiduciary liability. So a code section that we use a lot in our shop is 316. So 316 is a full fiduciary offset. That's literally where you hire a firm who acts as a fiduciary on your behalf. So they're taking all the responsibility off the table for you to the maximum extent allowed by law, and the government has condoned this and blessed it. Back in November, it was a unanimous decision in the Senate and the House to bless 316 planned fiduciaries, which means they know, the government knows, most people don't understand what this is, don't know how to fix it, and the government, again, is, although looking for money to fine for penalties, wants to have these plans be right. You can outsource this stuff. So you can outsource it through a 316 fiduciary. You also have to, or at least consider, getting fiduciary coverage. This is coming, so be mindful of it. Most of your property casualty policies, your business owner policies, owner and executive policies will not cover specific acts related to your plan, period. So be mindful of that. Just because someone says verbally over the phone, yeah, don't worry about it, Bob, we got this. Your policy covers everything. Slip and fall, employee accident, something falls on someone. Does it cover specific acts related to fiduciary breach? That's the term you want to know. If it doesn't, get a fiduciary insurance policy. Typically, it's very cheap and reasonable to add it on to your fidelity bond, which you have to have. Fidelity bond protects your employees from misappropriation of funds. It's required, has to be done for every plan. So most people already have them. Fiduciary is voluntary. That's voluntary insurance to protect those people who are named as those fiduciaries that we covered before. That's a big deal since you're, again, personally financially liable. Can't say, well, I was acting in a role at my job and my boss told me to do this and I didn't know. Don't fly. Here's where the teeth are, right? Criminal penalties, they're real. The average plan that was audited by the Department of Labor that was $10 million and more, 67% of those plans that were audited by the DOL resulted in fines, the average fine being over $600,000. Now that's a big example, right? Because we're using $10 million and up because that's the stuff that's out there. So rest assured, since that's the fastest area of governmental hiring is the Department of Labor right now to find such things, they will be looking for everything. And remember, everything's electronically filed. So it's a heck of a lot easier than when Ken and I got in the business and you used to have to manually pull stuff, manually look for stuff. Now they can just query the system. Hey, what was in box this? Did they have that in this box? Was it geographic to this area? They can pull things back, so be mindful of that. Fines for not doing the things you need to do. There is no max limit on this, which is why these fines are so big. It starts at $110 per day per employee with no look back and no look forward. There's no limit. So that's a big deal, which is PS, I think, why the government's looking at this, because it's been the Wild West forever and they need the money. So it looks like I'm done. How awesome is that? Yeah. Looks like as I transition this away. What questions do you have? Because I talk fast, I think fast. I don't walk fast. This is going to cover 401k and 403b. 403b specific if you have employer money going into the plan. So anytime there's employer money going into the plan as a 403b specific to 403b, then it would be considered ERISA. A 403b with no employer money can voluntarily opt to be under ERISA for the protections, and then you have to file, and then you're fiduciary, etc. Yep. Sure, man. So yeah, couldn't. So the question was, is a 403b automatically considered ERISA? The question is, the answer is rather, no, it is not, unless there is employer money that goes into it. Once employer money goes into your 403b plan, then it's automatically ERISA. It's weird.
We distribute our summary plan descriptions right away, but I never get a sign off or anything on it. I just have a tracking that shows we sent them. I mean, do I need to have an employee sign off that they received it?
Sure. So the question is, why does it do that? So the question is, we distribute our summary plan description, not electronically, physically, right? And you have a check off, but no sign off saying Mark received his, Dave received his, Ken received theirs. So the answer is, do I need to have a sign off? My comfort level is always, yes, it's always better to have a sign off than it is not, right? Because that's absolute proof. The DOL has mandated, no, you do not need to have it so long as it was done in an area that all of them can get. So I'll give you an example. It's very common now to have these digital human resource information systems, right? ADP Workforce Now, Total Source, bSwift. There's a lot of them out there where you can enroll and disenroll in the benefits, and you can use them to send stuff out electronically to your staff. So long as everybody has access to it, including an employee portal inside for those who don't have employee access at home, then technically that's considered distributions. But be mindful, it's not just the SPD. There's like 10 different notices you have to make throughout the year. So if you're making like a safe harbor contribution, you have to have a notice. You have to have the QDIA notice. There's a lot of notices that are supposed to be going out that most people just skim over because no one's looking. Any other questions? No?
Yep.
Yep.
That's another question.
Follow-up question?
Safe harbor,
Hmm?
we inform the employees that are receiving it. We don't inform everyone.
Okay, so the question is, so with the safe harbor contribution, for those of you who don't know, a safe harbor contribution allows an employer to make a contribution on the employee's behalf in two different ways, either 3% across the board for everyone based on eligibility, or a match, 3% and then 2% of the next two, right? Which makes it make you like, if you make 5%, you get a 4% match. So the summary on that is your SPD and your safe harbor notice has to go to everyone, not just those who are eligible. And here's why, because it's got to go in advance of the plan year. So let's say that you didn't make a safe harbor one year and you're going to make one the next year. And I decided, hey, listen, I'm not going to put my money in unless you're going to put your money in, but I didn't get the notice because I didn't participate last year. So the answer is everybody who's eligible for your plan, which is really just to submit it to everybody because they'll know if they're not because then it's in the SPD, would be required to receive that notice.
Somebody in the webinar has a similar question. If an employee decides not to set up an account for the employer contributions, do we need to get that in writing?
So the question is, does the employer need to set up an employer contribution account?
If an employee decides not to set up an account for the employer contributions, do they need to get that in writing?
No, so so the question is, so as an employer, if you're making a contribution on behalf of your employees, let's say that David's eligible, but he didn't defer his own money, so he doesn't have an account set up on my 401k because he didn't enroll. I can, as a trustee and a plan sponsor, automatically default him and enroll him into a plan. Typically, you want to use what they call a QDIA, Qualified Default Investment Alternative. So typically, that's like a target date fund. I set up the account, I notify him that's where it is, I pick the fund, and I put his contribution in.
Right, there's also another question. If there are no employer contributions, why would you opt to be under ERISA?
Hey, that's a good question, right? So as a 403B, so for A, it only applies to 403Bs. So 401Ks, employer or no employer contribution, you're ERISA out of the gate. 403Bs, because the rules were different for 403Bs, which typically apply to non-for-profits, churches, hospitals, yeshivas, things like that. 403Bs sometimes will opt to go under that ERISA standard because they don't want to have any terms of misappropriation or mispropriety. And oftentimes a lot of their board members who are coming out of the for-profit world want them to fall under same. Right, because at least you're held to a higher degree of accountability at that point.
But another question based on that question. If an employee, we have employees sign off that if they're leaving, but then the next eligible term, we give them the opportunity to enroll again, but we don't automatically put them in the plan.
Well, the question wasn't about for enrollment. The question was if there's an employer contribution. So again, you are making a contribution on their behalf, but they didn't opt in. So that could be like a safe harbor. So a safe harbor could be, I'm going to do 3% of everyone's pay across the board, but you didn't set up an account because you are not deferring money off your paycheck. Well, how do I put money into an account with your name on? You don't have an account. You never set one up. So I, as an employer, can open an account in your name for our contributions that we're making on your behalf and pick the fund and then let you know where it is. Now, so I say you want to use a qualified default investment because that's the only one that removes you from liability as an employer. And that's really important.
If they waive enrollment altogether, you don't have to do that.
Unless you're making a contribution. Correct. Cool. Excellent. Thanks, guys. I'm going to turn it over to my colleague, Dave. He's going to do a wonderful job on employment law. How was that, buddy?